Fantastic. Thanks, George. Morning, everyone. I'm Andrew Clarke. I'm a partner with Weightmans, specialising in civil claims against public authorities, private care providers, educational establishments. And I'm going to provide a legal update in relation to civil claims this morning, a quick sort of run through of lots of different cases in various different areas of law that I think will be of interest, hopefully, and relevance to your work. Thank you to Brett and to NASHiCS for asking me to speak today. And thank you to George, who's kindly agreed to control the slides for me this morning. Thanks, George. Can we skip on to the next one, please? So this is what we're going to cover this morning. So a real mixed bag of occupiers' liability, employers' liability, quite a few cases on vicarious liability, quick mention of a tree fall case, and then we'll just touch on what we've seen so far in relation to COVID claims against organisations that we're acting for. Next slide, please, George. So the first case I wanted to talk about was this one of Ashton and City of Liverpool YMCA. It's a High Court decision from 2023. Now, the defendant in this case is a charity, not-for-profit organisation which provided short and medium stay accommodation for vulnerable adults. Crucially, it was accepted in the case that while the YMCA provides support, including a contract that it had with the local council to provide accommodation, it didn't provide any form of social care. Now, the claimant in this case, Miss Ashton, was disabled, had a history of drug addiction and various psychiatric issues, as well as a criminal record. And in view of that history, the defendant provided her with a room designed for disabled users. And one of the features of that room was the lower than normal window level, albeit the windows had restrictors designed to prevent the window from opening too far. So on the day of the incident in question, the claimant had consumed alcohol and drugs and was noticed to be particularly upset and distressed. Prior to the fall, she'd been seen hanging from the window ledge and apparently shouting for help. Somebody took a photograph on their phone as they were passing by the YMCA premises, and the claimant then fell from the window shortly after that time. So she brought a claim against the YMCA, and the issues that the court had to determine were whether the fall was actually deliberate. The claimant had made some comments in hospital 2 weeks post-accident that she'd been attempting to commit suicide, and the defendant referred the court to those comments. So the court had to determine that issue, whether it was an attempt to commit suicide by the claimant. The claimant herself actually said in the case that she was trying to dry some washing on the window ledge as the tumble dryer within the YMCA was broken. So the court also had to determine the state of the window and the restrictor at the relevant time, any work that had been carried out to the window on behalf of the defendant prior to the incident, whether the condition of the window was a danger which presented a foreseeable risk of injury, and then whether that constituted a breach of the Occupiers Liability Act 1957. And that's the act that provides the duty to defendants to look after their visitors. It's a duty to take reasonable care to ensure that visitors are reasonably safe when using the premises. And the final question the court had to decide was if the defendant was liable, so if they found liability against the YMCA, whether there was any contributory negligence on the part of the claimant. Now, evidence of the state of the window on the lead up to the incident was very sparse. There wasn't much evidence at all. There was no contemporaneous evidence in the form of photographs or video or any independent inspection of the room. There's no risk assessment either in respect of the risk of someone falling out of the window. and the defendant couldn't produce any form of computerized maintenance or repair records because their system had been decommissioned. And finally, the logbook listing defects within the property had been misplaced. So it wasn't very good on the part of the defendant in terms of providing evidence as to the state of the room and the window prior to the incident. Obviously, if you are trying to defend cases, it comes down to contemporaneous documents, history, photographs, video showing, everything as far as possible to put then in front of the court so that the court can consider all of that evidence and make findings based upon that evidence. But in this case, that contemporaneous evidence was lacking here. The judge found that the claimant's fall was accidental, dismissing the claimant's comments that she'd tried to commit suicide. So it was an accidental fall from the window. When looking at the window restrictors, the court found the only restrictors in place on the window were those that were originally installed to the window frame. They weren't functioning effectively as the window opened wider than was deemed suitable, and there was therefore a foreseeable risk of a vulnerable person, such as the claimant, falling through that gap. The court found the defendant could quite easily and cheaply fitted additional window restrictors, and the court thought it was really surprising that the defendant had not fitted those restrictors, bearing in mind the vulnerability of its occupants. There was a finding of contributory negligence, though. The court reduced the damages down by 35% due to the claimant's intoxication. So she was going to then recover 65% of the full value of the claim. There was that reduction for contributory negligence because she was drunk or on drugs at the time of the incident. But I think an interesting case in relation to premises generally, and also the point again about records, that if you aren't able to produce contemporaneous records of the work that you've done, the risk assessments, method statements, all of that usual stuff, then you will struggle to defend cases should you have an incident. Next slide, please, George. Okay, so the next case is another one concerning occupier's liability. To do with a cleaning regime in a bar. It's actually in Leicester, where I'm from. I know this bar quite well, and I'm not going to comment on the cleaning regime in it, but we'll go through the facts of the case, and we'll come to the conclusion at the end. You're probably familiar with the HSE Health and Safety at Work stats from 2022 that illustrate slips, trips, and falls remain the most common cause of workplace injury. And similarly, they are the main cause of public liability incidents involving visitors to the premises. Now, in this case, Après Lounge and Wade, Ms. Wade was visiting this bar in Leicester, Après Lounge, when in the early hours of the morning, she slipped on what was thought to be a spilt drink close by to the bar. She brought a claim for injury against the bar in both negligence and for breach of the Occupiers Liability Act 1957. So she was a visitor to the bar, lawful visitor, and therefore the Occupiers Liability Act applied to her. It was accepted that the claimant had slipped in the manner alleged, so had slipped on a spilt drink, and consequently there was a case of negligence because the premises should not have spilt drinks on the floor. So the question that the court had to determine was whether the cleaning regime in place within the bar was reasonable, such that the bar can discharge their duty under the Occupiers Liability Act to ensure that she was reasonably safe as a visitor. Now, at first instance, so the first hearing, the claimant succeeded. The judge found that the bar's system of checks every 10 to 15 minutes was not sufficient to discharge the duty under the Occupiers Liability Act, and therefore she succeeded in her claim. So they'd said We go around and check every 10 to 15 minutes to make sure there's nothing on the floor. If there is, then we'll clean it up. And the judge at the first hearing said that wasn't sufficient and therefore liability attached. So the defendant, the bar, appealed on the grounds of 4 separate grounds that the judge was wrong in law to find that the checks every 10 to 15 minutes were not sufficient to satisfy the test under the Occupiers Liability Act. Secondly, that the judge had imposed an unreasonably high burden on the defendant, the bar, and therefore made an error in law. Thirdly, the judge failed to indicate what system they should have had in place. And finally, it was unjust that the judge found the system in operation was insufficient. So it went to an appeal hearing, and the judge at the appeal found the trial judge had imposed too high a standard, amounting to what was called a counsel of perfection. The standard required, according to the trial judge, would have been continuous surveillance and monitoring such that no drink could ever be spilt, and they'd need to have someone present on the floor of the bar at all times. And on that basis, it would be impractical and therefore unreasonable to impose such a high standard. Ultimately, the case came down to whether the bar system had amounted to taking reasonable care to ensure that the visitor, the claimant, and others were reasonably safe. And the judge found on appeal that this system of inspecting every 10 to 15 minutes was sufficient, and therefore she was safe when visiting the bar. Often with cases like this, they're very much fact-specific, and different judges are capable of reaching different decisions on the same factual basis. So consequently, measures what constitutes a reasonable system is basically a question of fact, but again, it comes down to documenting your system, risk assessing the premises, and putting into operation that system and being able to demonstrate it, sort of typical risk management approach. And in this case, ultimately on appeal, that was sufficient to be able to defend the claim brought against them. Next slide, please, then, George. So the next case I wanted to talk about in relation to occupiers' liability was this one of Juge and John Lewis partnership, which went up to the Court of Appeal late last year. Now, in this case, the claimant was an 83-year-old man, and he sought damages for a serious personal injury arising out of a trip and a fall which occurred in a Waitrose car park. The car park itself belonged to the local authority, the London Borough of Hillingdon. So it's their car park, and Waitrose and John Lewis have access to that car park, but it's managed by the local authority. The claimant was visiting the Waitrose store, parked his vehicle in the adjoining car park, and was injured following this fall. But he brought proceedings solely against John Lewis partnership under the provisions of the Occupiers Liability Act 1957. So he didn't go after the local authority, who were the actual owner and probably the joint occupier of that land. The accident happened when he was returning to his vehicle, and he stated that while he was putting his shopping away in the boot of his vehicle, he tripped on a curb which adjoined the disabled parking bay and then fell over. Unfortunately, he hit his head on the floor and sustained a traumatic brain injury with serious long-term consequences. So it's, freak accident, but sustained really severe injuries. Now, in the involving the local authority, they were the ones who collected the car park revenue, maintained the car park itself, and put relevant signage up around the car park. But the claimant chose not to issue proceedings against them, so the London Borough of Hillingdon, and solely brought proceedings against John Lewis. In the case, the defendant, John Lewis, had no licence or other legal interest in relation to the car park. It was shared with other local users of the high street and not exclusively for Waitrose John Lewis. The defendant, so John Lewis, refunded customers for up to 2 hours of car parking, and there was some branding displayed around the car park. If they had problems with it, they notify Hillingdon, the local authority, of those problems, and Hillingdon would then fix it. So it was a claimant's case that John Lewis, Waitrose were the occupier of the car park, and therefore they breached their duty due to the claimant falling over. So again, at first instance, this is a case involving another appeal, but first instance hearing, the trial judge found the accident was caused by the claimant catching his foot on the face of the curb. Although John Lewis, Waitrose, had sufficient control to be an occupier of the car park, that control was only limited to dealing with immediate hazards and then reporting them to the local authority. They were not entitled to or required to paint the curb to highlight its presence, or to put signage out to indicate that there was a particular curb there. Neither was it entitled to or required to make any long-term structural changes to the car park itself. The car park had a unique design because of this parking bay with the curb around it, and it did present a danger for disabled visitors using that car parking bay, and therefore there was a breach of Section 2.2 of the Occupiers Liability Act. But the curb itself was not defective, and the claimant was also fully aware of the presence of the curb, and his injury arose from what was simply, according to the court, a true accident. There's nothing that John Lewis, Waitrose, could have done or failed to have done which caused the injury. So the claimant lost the first hearing, and he then appealed up to the Court of Appeals. It went up to the Court of Appeal. And they found that the trial judge at first instance was correct in all respects. So the judgment was endorsed by the Court of Appeal. It found that the defendant was an occupier to the extent of their limited degree of control over the premises, and they then had a duty of care to visitors under the premises, but that only extended to reporting any issues to the local authority. They had no responsibility for the design, construction and layout of the parking bay, and the court found that the curb was clearly there to be seen, with no general requirement to warn of obvious dangers. There was no requirement on them to put a warning sign within the parking bay. So ultimately, the claimant failed on appeal, so his claim was unsuccessful at first instance and also on appeal up to the Court of Appeal. The court found that sadly he'd simply misjudged his manoeuvre and not lifted his foot sufficiently, catching his foot on the curb and then sustaining injury. But again, it shows there is such a thing as a true accident, and cases are capable of being defended provided there is sufficient evidence in place, as we discussed earlier. Next slide, please, then, George. So just a couple of cases on employers' liability now, starting with Chadwick and Ovenden and Hamilton. Case in the High Court from 2022, and it involves a really unusual factual basis of dismantling aircraft. The claimant was working for Mr. Hamilton, so he was employed by the second defendant, Mr. Hamilton, whilst undertaking the dismantling of aircraft at Manston Airfield, and that premises was occupied for the purposes of the Occupiers Liability Act by Ovenden, who's the first defendant. So he worked for the second defendant on the premises operated by the first defendant, Ovenden. So the claimant was dismantling an aircraft using an angle grinder, and unbeknown to him or anyone else, in fact, behind some panelling within the aircraft was a gas cylinder or canister. The claimant was using an angle grinder, and the inevitable happened. He cut into it and there was an explosion, and he sustained serious injuries. Now, both defendants argued that they didn't know of the presence of the gas cylinder, and therefore they shouldn't be liable for the claimant's injuries. They also said that the incident itself causing him injury was entirely unforeseeable. But despite that, their arguments, the court found them both equally liable. The court found that knowing the risk of dangerous substances being found on board due to the nature of an aircraft, the employer should have commissioned a comprehensive inspection of the aircraft prior to any work starting. And that would have included a safe system of work, a risk assessment, and a method statement. And that should then have identified any potential dangerous substances or implements on board. The court found that had both defendants commissioned that jointly, then the gas cylinder would have been identified, and therefore the harm which occurred was reasonably foreseeable, and both defendants were equally liable here. There'd been a failure to undertake that risk assessment, a suitable and sufficient risk assessment, and the court found that there'd been a litany of cut corners and unsafe practices in operation by the defendants. So both were held liable. Liability was 50-50 between the defendants on the basis that there was this lack of thought or lack of process in place prior to the works starting. So while the facts are unusual and probably very different to your work, the principle that comes from that is about, in advance of starting work, have those documents in place, your risk assessment, your method statement, your safe system of work, so if anything does happen, you're able to produce that and ultimately defend yourselves. Next slide, please, George. Lewin and Gray is another employer's liability claim involving the CDM regulations, so Construction Design and Management Regulations from 2015. Now, in this case, the claimant was working on a farm belonging to Mr. Gray, the defendant. And on the day of the accident back in 2018, claimant was working with his son, installing some guttering on the roof of a barn. Now, one part of this job involved getting roofing materials into a very narrow and sort of awkward part of the roof. And the claimant decided to use crawling boards in order to stand on the roof, to then spread his weight out across the roof and pull up the roofing materials to continue the work. As he was standing on the crawling boards to reach to get a piece of guttering, he slipped off the crawling board straight onto the fragile roof and went straight through it, unfortunately. He suffered very severe injuries, leaving him paraplegic. So he brought a claim against Mr. Gray as owner of the farm where he was working. And he alleged various things against him, but the case ultimately came down to a potential breach of the CDM regulations in relation to whether a breach of those regulations is sufficient to then sound in negligence. So was a breach of the CDM regulations sufficient to equate to a breach of negligence and responsibilities flowing from that? The case came down to two key issues in relation to the CDM regulations. So whether the defendant, Mr. Gray, owed a duty of care to ensure that the claimant, Mr. Lewin, produced a construction phase plan, and if so, did the failure to discharge that duty cause or materially contribute to the claimant's accident? Now, in the case, it was agreed that the defendant, Mr. Gray, was a commercial client for the purposes of Regulation 4.5 of the CDM regs, and therefore it was the defendant's obligation to make sure that a construction phase plan was produced by the claimant. The claimant said had that plan been produced, then it would have come up with different methods of doing this roof work, including use of a telehandler or a cherry picker to provide a safe platform for him. The court, in fact, found that there was no justification for imposing a common law duty of care and therefore liability for the failure to ensure that this construction phase plan was produced by the claimant. The judge said that a regulatory requirement for a client of building works to require the contractor to provide a document cannot, in my judgment, be equated to a duty at common law. So notwithstanding the fact there was a technical breach of the CDM regs because the defendant didn't ask the claimant for this document in advance, it didn't mean that the defendant was liable. So the claimant's claim failed as a consequence of that. So technical breach doesn't automatically mean that liability follows in this scenario. Next slide, please, George. So next, we'll just look at a few cases concerning vicarious liability. Now, this is the principle whereby an employer may be held liable for the actions of its employee. And it involves a two-stage test. So first of all, the relationship between the defendant and the wrongdoer has to be akin to employment. So are they employed, or is the relationship akin to an employment relationship? And if so, the second stage is whether there is a close connection between the wrongdoing committed by the employee and that employment, in inverted commas, relationship. So it's a principle whereby an employer can be liable provided that two-stage test is met, such that there is a relationship akin to employment and there is a close connection test between the employment and the wrongdoing. And there's been lots of cases in the last 10 years concerning vicarious liability, and it's an area of the law that is on the move, and it's developing regularly, and the courts are grappling with lots of cases concerning vicarious liability. And the first case I wanted to talk about on this was Ali and Luton Borough Council, which was a case I handled on behalf of Luton Borough Council. And it's an important decision for any organisation handling sensitive data. Now, in the case, an employee of Luton, who was identified as RB within the case, worked for the local authority's social services department as a contact assessment worker. The claimant, Ms. Ali, made a complaint to Bedfordshire Police about incidents of domestic abuse by her then husband. The complaint was shared by the police with the local authority as part of a multi-agency referral. Now, as part of her job, RB had full and unrestricted access to all social services records held on Luton's computer system. Importantly, though, at no stage did she ever work on the files related to the claimant, Miss Ali, or her children. So she had no reason to be working on those particular cases. Despite that, whilst at work on one day, she accessed a number of records related to the claimant's ex-husband, with whom she was then in some form of relationship. It's likely that RB took photographs of the records, which were then shared with the ex-husband and the wider community. Miss Ali was concerned for her safety as a consequence of this and suffered distress and anxiety. RB was dismissed by the local authority and pleaded guilty to computer misuse offences, and she received a suspended sentence, so 3 months imprisonment, suspended for 12 months as a consequence of pleading guilty to those offences. So the claimant, Miss Ali, brought proceedings against the local authority, saying that they were vicariously liable for the actions of their employee, RB. The court rejected the claimant's claim. It found that although RB had gained the opportunity to access the data of the claimant by reason of her unrestricted access to the system, that access formed no part of the work that she was engaged in by the defendant. She had no reason to access those particular records at all, and no justification for her going in and searching for the claimant's ex-husband. The court found the claimant was acting on her own agenda, basically divulging information to the claimant's ex-husband. She was acting on a frolic of her own, and therefore the defendant was not liable in this scenario. So she met the first part of that test we talked about. She was an employee. The case failed on the second part of the test because there was no close connection between the wrongdoing of RB and the employment relationship. So a very good outcome, but there's quite a few of these cases that I've seen around at the moment. And there was one involving Morrison's you might have heard of that went to Supreme Court, and that decision of the Supreme Court formed the basis of us being able to defend this case of Ali and Luton. But it is increasingly common, the sort of wrongful accessing of information on computer systems. Next slide, please, George. Second case on vicarious liability involves a prank or practical joke which went seriously wrong. Now, in this case, the claimant, Mr. Chell, was employed by Rolltech as a site fitter, and he worked on a site operated by Tarmac. He was providing services on behalf of Tarmac's business. Anthony Heath was a fitter employed directly by Tarmac, and one day he entered the workshop where the claimant was working, and he put two airgun pellet targets, which were explosive, down on a bench close to the claimant's ear. The claimant was bending down to pick something up, and then Anthony Heath hit those targets with a hammer, causing a large explosion and injuring the claimant's ear. So the claimant suffered a noise-induced hearing loss injury and brought proceedings against Tarmac, alleging they were vicariously liable for the actions of Heath. Heath was employed directly by Tarmac, and he was dismissed as a result of this practical joke gone wrong, this prank. The court found that the hammer itself was work equipment because it had been provided by Tarmac for people to use as part of their normal duties. But the pellet targets were clearly not work equipment. Heath himself had brought them into the workshop solely for the purpose of this practical joke. Heath had no supervisory role over the claimant at all. He wasn't even meant to be working in that workshop on the day of the incident. He only went there to do what he did with these targets, to do this prank that went wrong. So the question was around vicariously liability. Were Tarmac vicariously liable for the actions of Heath injuring the claimant? Limb 1 of the test was satisfied because he was employed directly by Tarmac. So stage 1 of the test is met. He was an employee. But the second stage was whether there was a close connection between Heath's role and the wrongdoing itself. And the court found that Heath had no function, duty, or responsibility directly related to the intentional wrongdoing. There'd been some suggestion of tensions brewing between Rolltech and Tarmac employees, but there was no clear evidence of that. Heath had no supervisory or managerial role over the claimant. It was a prank or practical joke that went wrong, and the claim failed. Tarmac were not vicariously liable for the actions of Heath in this scenario. So again, a good outcome from slightly unusual circumstances, but it's probably relatively common that people undertake practical jokes, and sometimes they do go wrong. So in that scenario, this case would be of application for you. Next slide, please, George. Sorry, skip on the next. No. Thank you. Yeah. So another case on vicarious liability is this one of MXX versus a secondary school, involving a work experience student who met a year 8 pupil who was the claimant in this case. So the work experience student was identified as PXM in the case, and he undertook a 1-week work experience placement within a secondary school in the hope of becoming a PE teacher. Now, the claimant met PXM during that week, and they sort of made contact on Facebook and exchanged various messages, and ultimately met up in person, where PXM sexually assaulted the claimant in August 2014. PXM didn't take any part of the claimant's PE lessons. There have been some discussions between them and possibly at an after-school club, but there was no sort of clear evidence as to how they'd met and what actually happened while he was in school for that week. So he committed sexual offences against the claimant and subsequently pleaded guilty to sexual activity with a child, as the claimant was only 13 at the time. The claimant brought a claim against the school, alleging they were vicariously liable for the actions of the work experience student in committing these assaults. And the court then applied the two-stage test that we've looked at already. Next slide, please, George. Sorry, just go back. I thought there was another one. So in the High Court at first instance, the defendant was found not liable. The judge found there was not a relationship here akin to employment. The work experience role was very limited and provided little help to the school. The entirety of the wrongdoing, the sexual assaults, occurred many weeks after the work experience ended. So the claim failed as a consequence of that. But the claimant appealed up to the Court of Appeal, and the Court of Appeal said that work experience can establish a relationship akin to employment. But then the next part of that test, the close connection test, is challenging for claimants. It requires a really strong link between the wrongful conduct and the nature of the employment itself. The appeal was dismissed, though, so the claim failed, as the work experience here was of such limited value and involved no caring or pastoral responsibility at all. It wouldn't be fair, just, or reasonable to impose liability on the defendant in this scenario. So the claim failed because of that lack of a strong link between the wrongful conduct and the nature of the employment. So they clearly met while the perpetrator was on work experience, but the work experience he undertook was of such sort of limited value that the court found there wasn't that link between the wrongful conduct and the nature of the employment. But I think that judgment potentially does open up the possibility of vicarious liability in a work experience scenario, should that link be strong enough in the right case in the future. Next slide, please, George. Final case on vicarious liability was this case of trustees of Barry Congregation of Jehovah's Witnesses and BXB, which went all the way up to the Supreme Court last year, so late last year. Supreme Court is the highest court of the land, effectively like the House of Lords was until the Supreme Court came into existence. So it's the highest court in the land. This is a really strong determinative judgment because it comes from the Supreme Court. Now, in this case, the claimant was a member of Jehovah's Witness congregation, and she was raped by an elder from the congregation in the back room of that elder's house in the afternoon, having being out in the morning, knocking on doors, talking about Jehovah's Witnesses. So the stage 1 test here was satisfied. The claimant brought a claim against the Congregation of Jehovah's Witnesses, and the court found that stage 1 test was satisfied. The relationship here was akin to employment. There was a close relationship between the church and the wrongdoer, which was akin to employment. So that stage 1 test was satisfied. The elder was carrying out work assigned to him by the Jehovah's Witnesses and on its behalf, so on behalf of the church. He was performing duties in furtherance of their aims and objectives. there was a process whereby elders within the congregation were appointed and removed, and there was a clear hierarchical structure. Next slide, please, George. So stage 2 was the main battleground in the case. The claim succeeded first instance in the Court of Appeal, but then the Supreme Court reversed the decision of the Court of Appeal that the stage 2 limb had been met. They found that the rape was not committed while the elder was carrying out activities on behalf of the defendant. So he'd finished his work effectively on behalf of the church in the morning, and this rape then happened in the afternoon after they finished their work within a private setting. The rape itself took place while he was abusing his position with the claimant as a close friend. And the court found that he was not wearing his metaphorical uniform at the time the incident occurred. So the claim itself failed, and the church were not vicariously liable for the actions in committing the rape against the claimant. So the claim was unsuccessful here as a consequence of not being able to meet that second stage of the test. Next slide, please, George. So moving on to a case concerning tree falls. Obviously, lots of landowners have trees on their land. We are seeing sort of extreme weather, probably driven by climate change, and trees are falling over and incidents are occurring. So this judgment, Parker and National Trust, I think is relevant to landowners, to organisations, businesses who have trees, and how they are managed is important if an incident does occur. So in this case, the claimant was visiting Lyme Park with her family, Lyme Park in Cheshire, and she was struck by a large branch which fell from a horse chestnut tree, and she sustained life-changing injuries. She brought a claim against the National Trust in negligence, alleging that they failed to manage the tree stock appropriately, and her injuries were a direct result of that. Now, the National Trust argued it had discharged its duty to the claimant by operating a comprehensive tree safety system. And at the heart of that was a policy of regular inspection of the trees. But they went even further than that. There was the closure of the park was put in place if there was high wind, and then there was always a system of post-storm damage inspection. So a really detailed and importantly documented system of tree management. As a consequence of that, the court found that the trust had properly discharged its duty to the claimant as a visitor to ensure that she was reasonably safe when visiting Lyme Park. It had a sensible and properly formulated and implemented policy of tree safety. The court actually found that the claimant's injuries were as a result of a tragic accident rather than any negligence on the part of the trust. So, a sensible decision, but again, a decision driven by the fact that they were able to evidence the system of inspection and its operation such that they met their duty of care to the claimant as a visitor in this case. Next slide, please, George. And again, please. Yeah, just finally on COVID claims. We, as a firm, have not seen any public liability COVID claims yet. Employers' liability claims have shown a sort of contraction in numbers. Numbers are down. And two sources of data are from Riddle reports, sort of 46,000 cases from the start of the pandemic to November 2022, and HSE stats, 123,000 reports into HSE between April 21 and March 22. Cases submitted to compensators generally are lower than they have been in terms of employers' liability and public liability. And we've certainly not seen any public liability COVID claims. We've seen a few employers' liability COVID claims, But I think causation here is going to be a huge hurdle, because it's going to be extremely difficult for claimants to prove that they caught COVID whilst at work, because they could have caught it on the bus, on the way into work, the tube, the train, could have caught it anywhere really. So I think causation is a significant hurdle, and that may well be the reason we've not seen any PL claims and not significant numbers of EL claims. But also limitation is now going to be an issue. 3 years to bring proceedings from dates of sort of knowledge of injury. And the first lockdown happened March 2020, so we're well beyond that 3-year period. So I think it's fair to say we anticipated large numbers of COVID claims, as did insurers, but it's certainly not transpired, which is a good thing, of course. But yeah, I think that's it then. George, is there one more slide for questions?